As I wrote in the New York Times, it is even more important than removing the president to push back on the notion of executive privilege, which has become a broader and broader concept in recent years. When you see arguments that seem to have a veneer of credibility, enough so that the president's legal team feels they can argue it with impunity, saying that the president actually has the right to block witnesses and refuse to turn over documents in his own impeachment trial, you know that that means that the Senate cannot serve as the check and balance that the founders designed it to serve. And so this is a moment of very serious constitutional crisis for our democracy, not because, or not only because, we have a president who is governing corruptly and who thinks he can do whatever he wants, but most importantly, because we have a Senate that is unable to act to remove the president because they are unable to push back on the president's own obstruction of the process involved in impeachment.
On Monday, Deputy Counsel to the President Patrick Philbin argued executive privilege is a constitutional principle grounded in the separation of powers and must be respected. This is what he said.
Second principle that the Trump administration asserted was that some of these subpoenas purported to require the president's senior advisors, his close advisors, to testify. Following at least 50 years of precedent, the Department of Justice's Office of Legal Counsel advised that 3 senior advisors to the president, the acting White House Chief of Staff, the legal advisor to the National Security Council, and the Deputy National Security Advisor, were absolutely immune from compelled congressional testimony. And based on that advice from the Office of Legal Counsel, the president directed those advisors not to testify. Administrations of both political parties have asserted this immunity since the 1970s. President Obama asserted it as to the Director of Office of Political Strategy and Outreach. President George W. Bush asserted it as to his former counsel and to his White House Chief of Staff. President Clinton asserted it as to 2 of his counsels. President Reagan asserted it as to his counsel, Fred Fielding, and President Nixon asserted it. This is not something that was just made up recently. There is a decades-long history of the Department of Justice providing the opinion that senior advisors to the president are immune from compelled congressional testimony.
So that's Trump's lawyer, Patrick Philbin. Professor Finkelstein, your response.
This is a really important issue to deal with. There were a lot of points that were not worth dealing with among the Trump legal team, but this is an issue that is worth dealing with because there is some truth to their argument that executive privilege has been used by other presidents consistently over time and has been expanding over time. But there was a lot of a misleading argument regarding executive privilege in what Patrick Philbin said. First and foremost in the history that he cited is that those presidents were not asserting executive privilege in the context of an impeachment. And it should be clear that executive privilege really has no role to play when the president himself is being investigated for misdeeds that could remove him from office. Now, the one exception to that is Nixon, who tried to assert executive privilege to withhold the tapes. But in fact, the Supreme Court ruled in U.S. v. Nixon that he did not have the right to do that, and that, in fact, he had to turn over the tapes. Yeah. And so we do not see executive privilege used in this kind of context to actually bar witnesses from coming to testify in a president's impeachment. There are other reasons why that is a misleading statement on Patrick Philbin's part, which is that the Supreme Court has ruled on other occasions that executive privilege goes too far. And so we see that this is an issue that needs sorting out rather urgently.